call a start to this meeting. Our good chairman will be here, but she's had to take a phone call this morning, so she's going to be just about probably 10 minutes late. So we'll start out. Are we live? Okay, and I would ask you to take roll.
Senator Cooper.
Here.
Senator French.
Here.
Senator Cole.
Present.
Senator Cost.
Here.
And Chairman Nethercott.
She'll be excused. Okay, we're all present. We've got a quorum. That's good. So we're going to start out. Today we'll be going with House Bill 71, followed by House Bill 83, and then House Bill 85. House Bill 71, Driving While License Suspended Enhancements Amendment. Representative Crago, you're the big man on this one, so come forward and present your bill.
Morning, Mr. Chairman, committee members. Thank you for having me. I bring to you today House Bill 71. Ask for your favorable consideration. It's really pretty straightforward. It actually originated. It was a request from one of our good county attorneys in the southwest part of the state. And really what this statute does is clean up a discrepancy in the law. And actually this law gets applied differently in different parts of the state. Some judges read it where if you have a prior conviction from another state, driving while suspended, and you're driving while that conviction is still in place, or while the penalty, while your license still is suspended, and you come into Wyoming and get a second conviction, that the enhanced penalty would apply, which is 7 days in jail and up to 7 days or minimum, of 7 days in jail. It's just set at that particular figure plus a fine. Some judges, though, read it literally, and if you actually read the statute, I think they're probably correct that a conviction from another state would not count towards the second or subsequent offense. What this statute does is just clean that up. So if you're driving with a suspended license, whether that suspension originates in Wyoming, Utah, Colorado, any of our neighbors, they would just be treated the same. This is how all of our other crimes are handled. If it doesn't really matter, whether it's a driving DUI or some other type of crime, other states' laws are given the same effect as ours. And so this is just an attempt to clean that up, to give our prosecutors some clarity, our judges some clarity, so that they know that, hey, it doesn't matter where the first or second or third or fourth DUS happened, it would still be applied the same in Wyoming. We have one of the circumstances that the county attorney that brought this to us had, a lady's driving through his county. She has literally 10 DUSs. She gets her first one in Wyoming. There's nothing they can do other than just give her the first offense, which makes no sense to me nor anyone else. And so that's what we're trying to fix. It's that simple. I'd stand for any questions.
Questions? Any of you? I have a question for you. Does the severity of that suspension have any weight on what would be classified? In other words, if the suspension was a DUI or something, does that have any more weight than somebody that was suspended for some other lighter reason?
Mr. Chairman, no, it does not. Under the statute, they're all treated the same. Driving while suspended is driving while suspended.
Question.
Go ahead, Senator.
Thank you, Mr. Chairman. Representative, as I'm reading the bill, all it's doing is just adding the fact that it's the same as in any other jurisdiction. Is that correct? There's no change to penalties or anything of that sort?
Mr. Chairman, Senator Cooper, that's exactly right. We're not changing the penalties. We're not enhancing them, lowering them. We are not doing anything with the penalties. Essentially, what we're doing is full faith and credit exercise here. Really is what we're doing, saying other states' laws are going to be treated the same as ours.
Okay. Any other questions? Do we have anybody to testify on this out there? Okay, come on forward. State your name and who you're with and talk to us.
Thank you, Senator. Committee, Josh Walther, I'm the Lieutenant Colonel for the Wyoming Highway Patrol. I'll make this brief. I agree with everything that's been stated so far. What we see around the state with our different jurisdictions is folks hesitant to write the citation or the must appear or arrest for the subsequent offense simply because of what's already been stated. So while some district county attorneys will work with us on the C, the subsequent offense, because it does reference A, where it talks about other jurisdictions, others won't. So what's happening is folks, as he mentioned, who have multiple suspensions out of state will come into our state and be pulled over, and our troopers are hesitant to write that subsequent offense just because they don't know how it will be carried through. So I agree. I think this just cleans that up. I think folks, obviously, who have multiple suspensions probably should be subject to a increased penalty, and they're not getting that a lot of the time in Wyoming. We're writing under A just because we know that's a safe bet. We'd rather have a conviction for a non-subsequent offense rather than nothing at all. So we find ourselves writing for A, where it talks about other jurisdictions. We do write roughly 1,300 to 1,400 driving under suspension citations a year, which isn't a huge amount for us, but it's still substantial. I think this would go a long way in sending the message that subsequent offenses on DUSs is not tolerated in our state. With that, I'd stand for any questions.
Okay, members, any questions? Okay. Thank you, sir.
Thank you, Senator.
Anybody else testify? None. There's nobody online, right? Going once, going twice. Okay, public testimony is closed. Move the bill. Do I have a second?
Second.
Okay, it's been moved by Senator Cole, seconded by Senator Cooper. Any discussion on any parts? Yes, sir. Senator Cole.
Thank you, Mr. Chairman. I'm very impressed this bill came through without changes from the House. That is saying something. Representative Gargo. There you go. Thank you.
Now let's be kind. Any other positive comment? Hearing none, no amendments, will you please take the vote?
Senator Cooper,
Aye.
Senator French. Senator Cole,
Aye.
Senator Cost,
Aye.
and Chairwoman Nethercott.
Leave it open for her, please. Okay. Thank you. Well, if all these go that quickly, we'll be lucky, huh? Okay, by the way, which one of you would like to take that one on the floor? Any volunteer to take it on the floor? Okay. We'll let you, sir.
Let me get something out of him anyway.
Okay, next bill up for us is House Bill 83. Protection of Parental Rights Application. And Representative Stiff, this is your bill.
Yes.
Short.
Mr. Vice Chairman, yes, this is a short 2-page bill. It does 2 things and it solves 2 problems. So on page 1, at the bottom, it amends current statute 14-2-206, protection of parental rights, by adding a new subsection C, which says that this section shall also apply in any judicial determination or adjudication regarding parental rights involving parentage, neglect, termination of parental rights, child custody or visitation under this title or under Title 20 of the Wyoming statutes. And then the remaining portion of this page two was a House amendment that essentially repeats the same language, but just puts that same language in Title 20. And the idea was that, so the first thing the bill does is it makes clear that what's hard to read about the bill, I think, is that what's missing from this is the section A and B, which is the parental rights statute. And so as you're aware, the parental rights statute provides that the liberty interest of a parent in the care, custody, and control of their child is a fundamental right. That's subsection A of 14-2-206. And subsection B of 14-202-206 provides the real teeth to the statute. It says that the state or any agency or political subdivision of the state shall not infringe the parental interest as provided in this section without demonstrating that the governmental interest is a compelling state interest addressed by the least restrictive means. And so subsection B provides the real teeth of the existing law, because it provides that if the state or any agency is going to take action to restrict a parent's rights, that it has to do so in the least restrictive means. So that's what the statute does. So in a case decided in February of 2020, the Wyoming Supreme Court held that on appeal, the appellant parent argued that the parental rights statute should apply in his divorce case to a custody issue. And divorces are decided under Title 20 of Wyoming statutes, not Title 14. And on appeal, the father argued that that the courts are part of the state or an agency of the state. And the Wyoming Supreme Court, in addressing that argument, said, we disagree. If the legislature, and these are the words of the Supreme Court, if the legislature had intended for the courts to comply with 14-2-206 in child custody cases, it would have said so, but it did not. Okay? So in that same paragraph, the Supreme Court went on to say that, well, this is a Title 20 case because divorces are handled under Title 20. This statute, the parental rights statute, is under Title 14. So therefore, if the legislature had intended for the parental rights statute to apply to married parents getting divorced under Title 20, the legislature would have said so. And for that reason, the court said that the statute simply doesn't apply to a custody issue in a divorce case. So what this statute does is say, yes, it's the legislature that makes the laws, not the courts. Courts really are state agencies. Courts are state agencies. And that this statute, that married parents will have the same rights as single parents, because as the decision leaves it right now, single parents have more rights than married parents. And there may be people who present and speak against this bill today, but the question I would like you to ask them is, why do they believe that single parents should have more rights than married parents? Because that's the state of the law right now, and it makes no sense. Is there some reason to believe that single parents are just better at parenting, so they deserve more rights, that married parents aren't as good at parenting? Obviously, that doesn't make sense. So what the bill does is on page 1, line 13, it says, this section shall also apply in any judicial determination or adjudication regarding parental rights. The word also there is kind of strange, right? Like, why would you say that? And it's because subsection B says the state or any agency or political subdivision of the state. And so this bill is, for example, not addressing or not targeted toward our department that deals with family services. Our Department of Family Services does, I think, on the whole, a fantastic job. By the way, I like to say this whenever I can. For child support enforcement, DFS is ranked #1 in the United States of America. It is the best at child enforcement in the entire country. This bill, if enacted, will have no effect and should have no effect at all on how the Department of Family Services does its work. It's not addressed to that. What this bill does say is that courts, you can't ignore this statute. So it solves two problems. One is it makes the rights of married parents the same as the rights of single parents, which I think is just common sense. I can't think of a principled reason why that wouldn't be true. And the other thing is it says that, yes, courts have to comply with the law too. And so it's an important principle to set forth, that it's the legislature that makes the laws and that the courts have to comply with them. So you may not be a fan of the parental rights statute. I mean, hypothetically speaking, if you were in the legislature in 2017, you might have brought an amendment to delete subsection B of the parental rights bill, which is the part of the bill that says that if the state takes away a parent's liberty interest, it has to do so with the least restrictive means. You may not have liked that. You may have drafted an amendment and sponsored an amendment to delete that out of the statute, right? Fair enough, but that's not what the issue is today. So the issue is not whether you like the statute as it was adopted in 2017, but whether it should apply equally to married parents and single parents. So with that, I would stand for any questions.
Thank you, Representative Stith. Yeah, that statute certainly has created an absurdity in the law, as you have experienced. Isn't that true?
I think it is very odd for the court to say, if the legislature had intended for the courts to comply with it, it would have said so. I find that statement very weird. And I find it very weird that we now have different rights between single parents and married parents. It doesn't make any sense to me.
And Representative Stith, do you recall who made that amendment?
You know, I believe it was the current chair of the Senate Judiciary Committee.
Indeed. All right. Thank you, Representative Stith. Questions for the representative? All right, seeing none. All of those who intend to provide public comment on this bill, I need you to raise your hands now. If you do not raise your hands now, you will not be allowed to provide public comment on the bill. I know there's always this dance that everyone likes to do in the room that they may provide public comment depending on the previous speakers, but that's not helpful to me running a meeting to understand how to allocate time accordingly. So if you do not raise your hand now, you will be prevented from providing public comment. Anyone online that'd like to provide public comment?
We have 2 people online that have their hands raised.
If you could let them in,
Okay.
whoever raised their hand first. And I don't get to see the hands raised. You might notice that I don't have a computer in front of me, and staff actually is the one that can see those hands raised and to see who's in the online waiting room to speak. I do not have knowledge of that. So just a little defensive of that still. Welcome, Ms. Spencer.
Good morning.
And welcome, Ms. Schwartz. I see you. Good members of the legislature. Here is another member of my law school class. You have met, I think, 4 of them this week, and 3 of them in the room currently. Welcome, Ms. Schwartz. Good to see you. We will start with Ms. Spencer. Ms. Spencer, welcome. If you could introduce yourself to the committee and then share with us your thoughts.
Sure. Thank you. Good morning, committee. My name is Cara Spencer, and I'm a practicing attorney in both Wyoming and Utah. I exclusively handle family law matters, divorces, paternity. Back early in my career, I handled a lot of juvenile court actions under Title 14. That's all I do, and that's all I've really been doing for 20 years. I also represented the mother in the Johnson case that has been decided today. And I circulated a memo yesterday that I wanted to briefly comment on.
Yeah, please, please do, Ms. Spencer. The public didn't get to see your communications to the committee. So if you'd like to summarize your thoughts here for the public's benefit, that'd be helpful.
Okay, so first of all, I think it's important, I mean, at least to me, when I'm looking at this bill, and I just think it's important to say this, I don't think this is a bill that should be either about domestic violence or about fathers' rights per se. I was bothered and felt compelled to comment on the bill because of the Johnson case being used as a basis for it. The Johnson case was a unique case, and I included the decision from Judge Blumel, if you all wanted some reading material, because I think it was important to understand the context of the Johnson case. And I think it's a real disservice to use that case as a proponent of fathers' rights. And then the other comment I wanted to make is I'm a big proponent of fathers' rights. I'm actually known more as an attorney who represents fathers in seeking equal time for their children. In Utah, there's more of a presumption of shared custody. So I have a lot of experience in that area and a lot of access to the research, which is clear that when you have a divorced family or in a paternity action, equal time or having a lot of access to a father is super important. That being said, it's discretion and each case is different. So I included the Johnson case because while Mr. Johnson in that case denied a lot of his acts were abusive, he admitted a lot of the things that I think are being misrepresented when you look at the facts here. And when Judge Blumel analyzed all of that, including his admissions of domestic violence in that case, the decision came down to the best interests of the children. And while Mr. Johnson's rights were certainly considered in that, the primary concern was the best interests of the children. So that being said, rather than focusing on fathers' rights or domestic violence issues with this bill, I think the focus really should be on the procedural problems with it. Mr. Stith, I just heard him say, why should single parents have more rights than married? They don't. Single parents do not have more rights than married parents. Single parents bringing a paternity action under Title 14 undergo the same analysis of the best interests of the children when determining custody. If there is to be any amendment in correlating the two titles together, it should be making clear that the best factor analysis under Title 20 applies to paternity actions, because that's in reality what happens. The only time the A and B sections are used when talking about least restrictive means and fundamental parental rights are when children are in state custody. So it's apples and oranges. When children are in state custody, the state must do certain things to get the children back to their parents. And the legislature has determined that it is a fundamental right and important for children to reunify and use reasonable efforts to reunify children, and by doing things that are least restrictive to the parent-child relationship. The state is an actor. The state is involved in that action. In fact, the state has custody of those children. And the other primary difference is in a Title 14 action, those parents could lose their parental rights forever. They could no longer see their children. This tie could be severed. Those children could be placed for adoption. A divorce context is very, very different. No judge in a divorce action can take away someone's parental rights. A judge in a divorce action doesn't have those same requirements that Title 14 actions bring. There's different time frames. There's different burden of proof. Title 14 actions have to be proven by clear and convincing evidence. They have to be done in certain time frames. Those same things don't apply to Title 20 actions. So when you try to incorporate these by referring to Title 20 in this amendment, it's a whole host of different changes that I think need to be considered. And the first would be, what's the burden of proof now? It's a preponderance of the evidence in Title 20 actions. It's clear and convincing in Title 14. And you need to really overhaul those things more broadly if that's going to be a change. I think a better route to be would to be incorporate the best interest actions into paternity actions. So I know that's a lot and it is complicated. It's not so easy just to say this applies to Title 20 actions, because there's a lot of things in Title 14 that are different than Title 20 actions. So, that's what I wanted to say. I tried to say that succinctly in the memo, even though it is a lot that goes into there. If you have any specific questions that you want me to address, happy to do that. But otherwise, I think those are the big problems with the bill. It would really leave judges and family law attorneys left hanging with what burden applies, what timeframes apply. And we have well-established law in divorce context that the primary paramount concern is best interest of the children.
Ms. Spencer, thank you. Questions for Ms. Spencer? All right, seeing none. Stay with us, Ms. Spencer. Keep Ms. Spencer on, please. We'll keep you on, Ms. Spencer, because I think it's important that we have both litigants here in the room. Ms. Schwartz, welcome. If you could introduce yourself to the committee and then explain your thoughts.
I can. Thank you. Thank you, Madam Chairwoman. It's a pleasure to be here today. My name is Kristen Schwartz, and I'm the Executive Director of the Wyoming Coalition Against Domestic Violence and Sexual Assault. Prior to being on the administrative side of the coalition, I was with our legal project and for 10 years, where I represented survivors of domestic violence, sexual assault, and stalking in primarily family law cases. And this is why I really look forward to testifying in this matter. I agree with the majority of what Ms. Spencer said. And I really don't feel like this has to be a father's rights versus domestic violence argument here, or that's the only thing that this committee needs to look at. Although I will say, if it was an advantage to people to claim domestic violence, and if they were able to be more successful in their custody cases because of that, I would have a much better win-loss record. And so I disagree that when people claim there's domestic violence, that they get a leg up within their custody cases. But I think what is so confusing about the addition of that this bill is asking for is it's going to really take away the court's ability to look at that best interest analysis in 20-2-201. What's different with Title 20 versus Title 14 is that you have rights that conflict with rights. It's not, as Ms. Spencer pointed out, the state coming in and taking children and having to provide clear and convincing evidence and the least restrictive means. You have two parents with constitutional rights to parent who are coming to a decision on custody after those parents are no longer together for whatever reason. And that's why when you have paternity established in Title 14, you go to the best interest factors of Title 20, because once paternity is established, now you've got two parents with rights. And so the court is asked how to make that determination. And that's why the determination at the court's discretion has to be those best interest factors and not some other constitutional parental right, least restrictive. They have to have that discretion. They have to have that ability to go forth and really look at the family situation and come to a conclusion. We have to remember, and I want to hold how complex family law is, how hard divorce is, but in a Title 20 action, two parents are asking the court to make a decision. They're unable to decide for whatever reason what is in the best interest of their children. And so they need the court involved. This isn't the state coming in and forcing two individuals to get a divorce or split time with their child. And therefore, the court has to see each child individually. The court has to see each parent individually, and then make a determination that's in the best interest of the children. And I can understand that sometimes that's hard. The deference of the district court can be hard for parents. It can be hard for attorneys who are advocating for parents, but there really is no better way. I do believe that parental rights are protected in Title 20 as it stands now. I think the court needs the ability to protect families and specifically to protect children, and that it should, that the law should stand the way that it is. And with that, I yield my time for any questions.
Ms. Schwartz, thank you so much. Questions for Ms. Schwartz? Ms. Spencer and Ms. Schwartz, if you can, both maybe just real briefly, were you aware when this parental rights bill was before the legislature and then passed into law? And do you have any kind of just general thoughts about that?
The 2017?
Correct.
No, I was not.
Ms. Schwartz, were you aware?
Briefly, I was aware. I wasn't on the administrative side, so just really looking as a family law attorney in Wyoming. Again, to me, it made more sense to have it in Title 14 because you're looking at state action and taking away parental rights. The ability to lose your children to the state needs to be heavily protected. So that's all.
Do either of you think it's even necessary to be in Title 14, or just creates further confusion? That would be a leading question.
I think it's fine. I think it's fine.
Okay. Yeah.
Codifies constitutional law?
Correct.
All right.
And that's because Title 14 actions are just so different. Those parents could lose their children forever.
All right.
And if I may, Chairwoman, I think you bring up an excellent point that parental rights are established in constitutional law, and so it's really redundant. And so we do have it. It's not that they go away in Title 20. We have it, but what we have in Title 20 is two parents who have that constitutional right to parent their children.
Thank you both. Any final questions for Ms. Schwartz or Ms. Spencer? All right, seeing none. Further public comment on this bill? Please come forward. Anyone else in the room that wants to provide public comment? I see people coming in and out. Welcome, good morning. If you could introduce yourself to the committee.
Good morning, Chairwoman Nethercott, Senate Judiciary Committee. My name is Sean Murphy, and I'm here today because I'm a parent, and I would like to share my story and the relevance, the direct relevance to this legislation. I'll keep my comments as very brief, but I think you'll understand as I share this why the real matter here is that parents aren't being heard in this country. They're not. And when parents aren't being heard, that's a problem. So I'm here today to be heard about this legislation. I have a sick child. His name is Atlas. He has a terminal brain disease. Shortly after he had a brain hemorrhage, there was a dispute between his mother and me, and that was whether Atlas should have all of his 2-month vaccines 1 week after surgery when he was 2 months old, and whether or not we should look at CBD from hemp, non-psychoactive, to help reduce inflammation in his brain. And this created a clash between parents. And within a matter of days, there were all sorts of allegations made about me, domestic abuse, child abuse. All of the guns came out that happened in divorce court. And it transpired into what has become 3.5 years of litigation. In this case, and this is in Colorado, but many of the mechanics and laws operate the same way across states. The court ruled that it was in the best interest of the child to reduce conflict. That us two parents, we couldn't decide together, so the court had to intervene and decide which parent should. And in family law, I'm not saying always, but typically that is with the mother. And there's good reasons for that, and there's some wrongful reasons for that. But the issue has consistently been, is that a fundamental right to share in the decision for your dying child? Do I have a fundamental right to say what goes in or not to my child's body, what experimental clinical trials he's in? Is that a fundamental right in our Constitution that a parent should share in that? As it is in Colorado, in my case, I don't have that right. The court deemed the best interest of the child was to reduce conflict, putting the best interest standard above the fundamental right standard. And I understand the great interest and lobbying by the domestic violence group, that domestic violence and abuse is very serious. But that's not always what's going on in divorce court. That is sometimes or typically a tool used to create conflict and leverage in the law. I understand the judiciary doesn't want to limit its powers and change any laws and restrict its ability to have total say under best interest standards and not apply the constitutional standard. And I understand that attorneys profit from this system. They profit from conflict. And these are special interest groups that continually arise in shared parenting or parental advocacy that I've become intimately aware of the last several years. So I appreciate you listening to my story. I'm educated on these matters. I'm not a parent that sometimes dads are, the deadbeat dad or the domestically violent dad. That's not me. And when people start telling those stories, they come against the history of who I am as a Twilight Brigade hospice volunteer in the VA and Knight in the Order of Malta. And this is a very serious issue because parents aren't heard with this. It's moved into the realm of attorneys speaking for everyone and holding this system in a control state where it's not the parents that are ultimately resolving these issues, but the court does on the best interest. And most of the time it works well, but there are cases like Representative Stith's case and others where the fundamental right standard is the last bastion for a parent. And that makes this very important, and this will ultimately arise in what I believe is the shared parenting movement that has begun in this country. And it's a matter of parents being heard. And I didn't feel heard. 2 days ago, I was in the Senate lobby. Chairwoman Nethercott, you're very busy and understandable. This is incredible pressure, everything you guys have going on.
Let's speak to the bill.
Yeah, but I asked you what you thought and if you read the bill, and I'm not going to share what you told me about it, but it just made me realize that this matter of being heard is very important. And I really appreciate you hearing me today. I really do. And these are matters that they usually arise in when there's conflict. And I appreciate your good consideration. This really is an appropriate use where the judiciary needs to follow the intention of the legislature. That's what was done into law several years ago. And what we're seeing come in here is the judiciary saying, we don't want to apply this. We don't want to limit or reduce our ability to decide. And that's my observation. And I'm not saying there's anything wrong with the Supreme Court's ability to do that, but it's understandable. But is it right? Is it right? Is it based on the constitutional intent of parenting fundamental rights? Or is it based on the best interest standard where the court wants to be able to make things easy and have total decision and not apply the constitutional amendment? This is an issue I believe that's going to keep coming back if we don't apply this amendment as it's written and truly show legislative leadership on this and support parents. So I leave you with that question. What happens, when parents aren't heard in this country? What happens when it's attorneys and the judiciary doing all the talking for parenting rights?
Thank you, Mr. Murphy. Appreciate your comments here this morning. All right, we'll move on to further public comment. The time is 8:39. Ms. Lance, welcome. If you could please introduce yourself to the committee.
Good morning, Madam Chairwoman. My name is Beth Lance. I'm here today on behalf of the Wyoming Trial Lawyers Association. As I'm sure all of you are aware, we have many members within our association who are family law attorneys. And so this is an area of law that they practice in constantly on a daily basis. And that consists sometimes of cases under Title 14 and sometimes cases under Title 20. I would first just start with this case that has brought about this legislation from the Supreme Court, Johnson v. Johnson. Just to state on the record, I'm not sure anyone would read this case and feel that the outcome was incorrect. In this case, the father had been found to have been extremely abusive. He had murdered family pets in front of the children. He had raised one of the children up by their feet in order to beat them. He had constantly beat the mother, often in front of the children. The outcome of his case was that he had to have some supervised visitation. There were things he could do to maybe change that in the future, but his visitation was ordered to be supervised for the safety of the children. And that is ultimately the outcome of that case. And so I just think it's important to understand, I'm not sure this was a case, often this committee looks at cases and if they feel the court maybe got something wrong, or if they feel that legislation is required to fix something that the court may have done. And I'm not sure this is one of those cases. Not to belabor the point, I know you've heard now the differences, I think, between 14 and 20. But Title 14 is a parent versus the government. And so that's a very different thing. That's a case where it was codified into law, the strength of the parental rights, right, in Title 14, because that's a parent versus the government. That's a different place. But when we're looking at Title 20, that's a parent versus a parent, typically. In Title 20, as Mr. Murphy described, parents have come to a standstill. They can't agree on something. They're unable to, decide on visitation or decide on things for their children, and they have to appeal to the courts to assist them in coming to a conclusion or a decision that they need to have decided. They arrive in that court both with full parental rights. That they're on even ground. Moms and dads have equal parental rights. And so that is there regardless of what it says in Title 20, because that's just a constitutional right. That's within the Constitution already. What the court then does is, because they're there on equal footing, the court then begins to look at what's best for those children. And then that's the analysis that occurs. I think the concern is, what does this bill do? I think the concern is we don't know. I think the concern is judges may not agree on what this bill means or what it does. And I think we're going to create potentially a lot of problems when I don't think we currently have a problem to solve. Would it negate the best interest analysis? I think you've heard from other attorneys today that it might, and that is a concern. What would our results in cases be if we were to not look at what's best for children anymore? So those are some major concerns with this legislation. Additionally, there were comments from Representative Stith that I continue to be confused by. He's saying that single parents and married parents are not treated equally under the law right now, and that somehow this legislation changes that. And I just want to make clear, under Title 14, often parents are married. They may be married and they may be brought together before the court for an abuse or neglect action. Sometimes they're not married and they're brought, one individually or the other. And in Title 20, often people now have children that have never been married. So no divorce is necessary. They're two single people who share a child, and they're there in front of the court to determine custody or visitation, but marriage has nothing to do with their case. And so I just think it's important to understand we are just looking under the law at parents, period, and their constitutional rights. Their marital status actually has nothing to do with their parental rights. I would stand for any questions.
Ms. Lance, thank you. Questions for Ms. Lance? All right. Seeing none, Ms. Lance, just a quick question. In Title 20, which are those family law custody cases, just to maybe clear up concern based on previous testimony, in Wyoming, is there a presumption favoring any particular type of custody?
Madam Chairwoman, no, there is not. And our Supreme Court has made clear that any custody may be ordered in the best interest of the children, including shared custody. And we are often now seeing many, many more of our cases are shared custody results.
Thank you, Ms. Lance. All right, the time is now 8:45. Any final public comments? Anyone else online? 2 minutes, Representative Stith.
Madam Chairman, thank you. I'd like to respond to some of the comments. First off is the ad hominem attack that I find very strange. We celebrate Miranda v. Arizona that protects the right to be informed of your right to remain silent if you are in custodial interrogation. But Ernesto Miranda was a rapist, a kidnapper, and an armed robber. We don't determine whether the constitutional right is good or not, depending upon whether we like the litigant. And second, I appreciate the comments of Ms. Spencer and Ms. Lance and Ms. Schwartz, but they're not addressing the issue. In Title 14, you can have identical cases. You have a non-married parent, a single parent, whose paternity is being adjudicated, and as part of that adjudication, you're adjudicating what their visitation is like, okay? Is your visitation going to be supervised or not supervised? And there's a big difference between supervised visitation and unsupervised visitation. Supervised visitation means you go into a room and the government watches you while you interact with your child. And that's certainly appropriate in many circumstances. If you're a single parent, your custody rights will be determined under Title 14. And under Title 14, we have this parental rights statute that says when the judge decides whether you should have supervised visitation or unsupervised visitation, the judge has to decide that supervised visitation is the least restrictive thing that the judge can do to achieve the compelling state interest of the best interest of the child. But if you're a married parent, the judge, under the current Supreme Court decision, makes that same custody decision, whether you get supervised or unsupervised, and does not have to use the least restrictive means. And that's the difference. And talking about all of the different kinds of neglect cases and termination of parental rights cases that you can have in Title 14 is simply not relevant. And so frankly, the comments by Ms. Spencer, Ms. Schwartz, and Ms. Lance are not relevant to this discussion. This bill, all it does is it says that these constitutional principles that are set forth and codified in statute apply in both to the married parents and to the single parents. And the state action here is not the action of our Department of Family Services taking away your kid or the police taking away your kid. The action here is the action by the judge. The action by the judge. And the judge and the court has said we're not a state agency. And if you look in your budget bill, you'll see that each individual district court judge is a state agency. Agency numbers 121 through 143. So this bill says they are a state agency and that married parents have the same rights as single parents. Thank you very much.
Thank you, Representative Stith. Creative argument. All right. Public comment is closed. We're just running out of time. The time is 8:48, and I know the next bill up is has a great deal of public interest, so I want to make sure we have plenty of time afforded to that as well. Any final questions from the committee? All right. Committee, back to you on the bill. Moved by Cooper. Seconded by Senator French. Discussion on the bill.
Question.
Seeing none, roll call vote.
Senator Cooper,
Aye.
Senator French, Senator Kolb,
No.
Senator Cost,
No.
Chairwoman Nethercott.
No.
Madam Chair, House Bill 83 engrossed fails with 2 ayes and 3 noes.
Thank you. Now the time is 8:49. We're going to move to House Bill 85, Child Endangering Controlled Substances Use While Pregnant. I see the sponsor of the bill, Representative Oakley, is here with us now. Please come forward, Representative Oakley. Just at this time, I'd like to get a sense of those interested in providing public comment on this bill. And again, I need you to raise your hands now so that I can allocate time accordingly. Again, I know there's that desire to see how other people may testify, but I need you to do it now. 2, 3, 4, 5, 6, 7, 8, 9. And then we have 1 online. So there's 10 total folks to provide public comment. The time is 8:50. We need to adjourn this meeting in exactly 1 hour at 9:50 because we'll gavel in upstairs for the full Senate session at 10 o'clock. And so that gives us enough time to get ourselves upstairs and adjourn this meeting with a very little bit amount of time to work this bill if necessary. So I just want the public to understand that we'll probably need to limit your testimony to a matter of minutes in light of the need to hear from everybody. I don't want to miss anyone to provide public comment. And the only way to accommodate all the speakers is then therefore to limit your time. So after we hear from the sponsor of the bill, we will go ahead and limit the time of those preparing to provide public comment based on the amount of time we'll have available after the sponsor. So Representative Oakley, please proceed.
Thank you, Madam Chairwoman. Amber Oakley, representative for House District 55 in Riverton. And good morning to the Senate Judiciary, and I'm pleased to be here. So I bring to you House Bill 85, which adds a new subsection C, to a child endangering. What it says is quite simply, no person while pregnant shall knowingly consume methamphetamine or a Schedule 1 or 2 narcotic drug. I think that's important. I know there was some discussion about marijuana. Marijuana is specifically not a narcotic drug, and we have narcotic drug defined. And so actually an amendment was brought to include that even. So you'll see that there, the 35-7-1002 defines the narcotic drug. And so what I will do now, I'll just tell you just a little bit about why I bring this to you. In my opinion, I brought it because I believe that there's kind of a hole in the law, possibly unintentional by the legislature. And of course, in the law, we presume that it's not unintentional by any previous legislation. But so prosecutors did think it was illegal to do this, or at least some, and consume methamphetamine while pregnant. So they brought a charge. And then we've got decisions by judges, both as a felony, and then later I again tried as a misdemeanor. Both were dismissed, saying that, you know, getting into saying it's not a child by law. There's a definition of child. And so what I thought is, well, then let's just talk about the conduct that we're trying to prohibit, and say you can't consume methamphetamine when you're pregnant. Which, as I said, I think a lot of people thought was illegal conduct. And at the end of the day, it comes down to, as far as I'm concerned, it's as simple as that. A policy, as policymakers, do we want to say that's prohibited conduct? And I would say that most Wyomingites would consider that something that we want to have illegal. That it's something that and I would say I don't at all think it's a stretch in our law. First of all, of course, we're looking at subsection C. So A and B already prohibit for a child to be in the same room as methamphetamine. For you to allow a child, of course, to absorb or inhale methamphetamine. It's illegal to even possess methamphetamine. It's illegal to use methamphetamine. And so, and then arguably the most dangerous conduct, this is not prohibited in the law. I would submit that shouldn't be that way. So I bring this bill. So interesting, bringing a bill. I was surprised at the pushback. So there's been some good discussion, some robust discussion, and I even brought an amendment to address some of those concerns. The first concern being, we want to care and support women, not just incarcerate them. So we had some discussions, and I said, I promise you, like these other charges, these 5-year felonies, the first thing they do is go to probation. We will absolutely work on treatment. That's what the criminal justice system does. But so in order to assure people, what I did is I brought an amendment, and it doesn't exist anywhere in criminal law that I'm aware of. This would be the first time, but it says upon a first offense, the defendant shall receive treatment and probation. So there would be no discretion for a prosecutor or a judge or a plea agreement to go straight to incarceration. Because at the end of the day, that is what we're trying to do, is ensure the safety of children and of the mother. But then, I hear a lot that we have to, we really need to focus on treatment, which again, I submit to you is what's happening. And the answer is that we just need to continue to expand substance abuse treatment and services for women. But if you actually look at it, we have robust services for women, for families, for people, state funding, federal funding. We have the Department of Family Services. We have counselors throughout Wyoming. We have 12 community mental health centers with both outpatient and residential and substance abuse treatment tracks in all 23 counties. We have 3 residential facilities for parenting women currently. They're looking at expanding that. And again, that's within our purview as the legislature. If we want to expand those, then we can do that, and we can discuss that. But that doesn't mean having access to service doesn't mean that this should not be illegal behavior. And one of the things I would say that I hear when with the pushback, that we just need to support women more, I absolutely think we should. I support that effort. But what I notice is there's also no discussion about truly the consequences of this behavior. It's extremely costly in terms of not only, money, but we're willing to put that into it. But the mental, the behavioral, and the physical health of the child, we're not discussing that. And what happened is there's been this huge increase of these children. And again, I would say that that's the piece that I'm not at all hearing from people who are against the bill. So very quickly, according to a national study of children's health quality, 20,000 babies are born addicted to drugs like meth in the US every year. A baby who goes through extreme withdrawal symptoms is born every 25 minutes. And 27 out of every 1,000 babies were born addicted to narcotics. So I've also been given one study, that's the only one that's been quoted, but it's been quoted a lot, saying this would cause women not to seek treatment. But when I actually look at it, the study, it says that in 8 states that do have the punitive measure, this increased greatly. The children that were born in withdrawal symptoms or with symptoms of being a drug addicted baby. But it seems to me now they're drawing a causal connection when the whole thing is we've had this opioid increase so much. So for example, they used Kentucky as one of those, saying, using a causal link between having punitive measures and having drug addicted babies. But in Kentucky, the rates of children born drug addicted went from 46 in 2001 to 1,115 in 2016. I think that was going to happen either way, as we've said, this increase. I don't think that's causal because the Kentucky passed a law saying that this should be illegal conduct. So I push back on that too. The reality is this is a way that we can hold women accountable. Without it, we don't have that. It's a carrot and a stick, but that is used over and over and over again in the criminal justice system and has some of the best results because you have the compliance piece. If a woman chooses not to comply or to take advantage of all the programs that we have, there's nothing that can be done as far as expecting compliance, doing your analysis tests, ensuring that the woman is complying. We can use the statute to do it. And in addition, I believe that as a policy choice, we as the state of Wyoming would stand for that this should be illegal prohibited conduct. And that takes you through the bill. Oh, I do have one more thing. I meant to have it ready and I apologize. So in that amendment, I referred to the, since it's mandated to do probation, I referred to the AESI ASAM, and that's a proprietary that could change. So it was brought to me to say, and I think the fix for that is easy, of just the evaluation that's in the PSI. The PSI is in statute that they have to any felony has to go through a PSI process before sentencing. So using the generic language, I think we should change it to, they would have to get an evaluation via the PSI and follow that evaluation. So I apologize that I didn't already have that done. And I'd stand for questions.
Thank you, Representative Oakley. Questions? Senator French.
Thanks, Madam Chair. Representative, just a question. How is it determined that the babies got meth? When they're born in the hospital, is there a chemical or a test? Because I don't know what the percentage, but there's a number of babies born at home, with a midwife or whatever. So how's it, who determines it? Does the hospital run a test on every baby? And they say this baby's got meth in it.
Representative Oakley?
Madam Chairwoman, Senator Fredge, thank you. That's a great question. This is, I think, an important policy for some people who are against sort of this idea, which is this does not include mandatory reporting. And that was important to counselors and doctors, and I agree with that. This doesn't entail that. The two cases that I had it was before my time, actually, the 2005, the felony case that was dismissed. She was on probation already for a methamphetamine offense. And it was reported via family, so they went and did testing that way. And both she and the baby were positive for methamphetamine. And so I think it really will be much less used than you might think, which is fine. Because there's only certain instances in which the state would be informed of it. So for instance, if a pregnant woman was going to a counselor, that counselor is not going to report it. And again, that which in that way is I guess a good thing for detractors of this bill. This isn't going to be, this doesn't all of a sudden allow the government to go be running around testing, give me your arm or your urine. There has to be a process by which that happens. But I think we have had a couple in the hospital that were already, on probation and showing to be a danger. And because we weren't able to charge them, away they went. And then we didn't have any compliance. And I am concerned about, there was no check for that woman.
Representative Oakley?
Mm-hmm.
I'm struggling to understand how all of these women that are currently already on felony probation or even misdemeanor probation in circuit court couldn't have been revoked for the already illegal conduct of consuming narcotics. It's illegal to use, regardless of whether you're pregnant. And so they're on probation, subject to supervision, subject to drug testing. They've obviously tested hot. Why they couldn't be revoked, I'm uncertain, one. And then two, why they couldn't be charged with another charge if that's what the prosecutor wants to do with use of a controlled substance. Help me understand that.
Thank you, Madam Chairwoman. So I agree with, certainly behind that, I would say that both the use is a 6-month misdemeanor, sometimes not, and I'm assuming it was supervised. It might not have been. So what happened is, because it's flagged as a lower level, it has nothing to do with her current condition. So in that case, I'm assuming that the agent, or she didn't have an agent, or the agent wasn't testing her. And so in a way, that's why this would be important. So as she goes forward, so let's say she had 60 days suspended and has a month or two left when they found her in the hospital. This gives the opportunity to put her on meaningful supervision and demand compliance again, where I don't think you can get that via a use charge. And of course, and it's tough because that's one scenario. I mean, as you know, the facts are as different as people are. I will say in that felony case, then she went home. I believe that she did not raise the child, and then a little over a year later was charged with 3 counts of delivery of methamphetamine. And again, I think if we could have gotten it right at that time and had some compliance at that time, it would have been better off for the woman and the child.
Senator Cost.
Thank you, Madam Chairman. Representative, this might stretch a little, but we know there's fetal alcohol syndrome, and I'm sure there's probably cases with marijuana. Why do we stop at methamphetamines and those drugs? Because we have these children that face fetal alcohol syndrome and all as well, and those are drastic results in the end as well. So why stop where you stopped?
Representative?
Madam Chairwoman, Senator Cost, again, another good question. I would say that that's also a policy, that for a separate bill that we could discuss. I think if I were to take a stab at it, so this is in a section of child endangering that has to do with methamphetamine and drugs that are completely illegal, right? Like, it's never legal to use methamphetamine. And then this section, this child endangering, cuts out when it's even more dangerous that you're using these methamphetamine around children, having them in rooms, and possibly ingesting while you're pregnant. The idea of monitoring what a woman's drinking while she's pregnant and how much is a much larger, I don't even know how to, you're talking about a very illegal substance that's very often used, and how much is too much. That's a very difficult thing to get at. I agree. Fetal alcohol syndrome, we have a lot of it in my county, and permanent long-term consequences to the children. But it's just it has its own issues and would have, its own discussion as far as policy, which just isn't here today. But I agree with your sentiment, Senator.
Kind of following up on that, Representative, I do think it's here today because of the way that the bill is structured. This bill is under the criminal section associated with child endangering as opposed to use of a controlled substance. So certainly, depending on the consumption of alcohol, which is legal by a pregnant woman, certainly does endanger a child. We know that through fetal alcohol syndrome. So does a lot of other legal conduct, which still may be considered child endangering if it endangers a child. So rather than putting use of a controlled substance while pregnant as the crime, this is actually a child endangering statute. So I do think all of that lawful conduct is wrapped up into here and is part of that policy conversation, rather than having the bill structured completely differently under use of a controlled substance with some other type of penalty if one is pregnant or known to be pregnant. But that's not the bill before us. So Representative Oakley, comments to that?
Thank you, Madam Chairwoman. So again, this is actually specifically endangering children as it relates to controlled substances. 64405 is child endangering as it relates to methamphetamine and Schedule 1 and 2 narcotic drugs. So it does not encompass legal alcohol. And I get, there's different discussion about where it should go. I believe that it just actually fits to me because when you look at subsection A and B, this is, what we've determined to be 5-year felony level as it relates to methamphetamine, and that's completely what this is. And in the end, both of the cases that, that we had in Fremont County that judges dismissed was in relation to a child that was born. Their methamphetamine was found in their blood. So I tried to take it as a misdemeanor. Quickly, you'll understand this. The judge just didn't hear my argument, but what I did was a date range so that the conduct that was prohibited doing the methamphetamine was before, and I went through the birth of the child so that we had a born child, and so I did a 2-week, which I think my argument would have worked, but the judge just didn't really address it, used this other case and dismissed. But so because of that, it actually did seem to make sense to me logically to have it in this section, which is about endangering children and methamphetamine.
Senator French.
Thank you, Madam Chair. Representative, how long, when a baby's born with meth, how long does that baby test positive?
Representative.
Thank you, Madam Chairwoman. Senator French, I should know better. I don't, if I were guessing, I would say probably a week. Methamphetamine isn't as long as some other drugs. Unfortunately, I'm not the drug expert in our office. But it's not too long that I think that the metabolites would show in the blood. Of course, the effects would be for much longer, but But actually testing positive for it, I don't think would be very long.
Senator French.
Madam Chair, just a quick follow-up. The reason I ask is if somebody's going to report a mom that, you know, there could be an issue with, they got a very short period of time because that baby, if it's a week, you know, it's got to happen pretty quick or the baby won't test positive for meth. So that's the reason I asked. Thank you.
Representative.
Madam Chairwoman, Senator French, excuse me. Yeah, I would agree with that. And usually I assume if you're talking about getting their blood, it would be at the hospital, because after that it could have passed through breastfeeding, let's say, in which case, again, the government is held to a beyond a reasonable doubt standard. So then there would be a plausible defense. In which case, so again, I do believe it's narrow. It would have to be proven. This is a criminal statute, so.
Further questions for the representative? Senator Cost.
Thank you, Madam Chair. Representative, the last one I have is, do you think, I know you've alluded to it a little bit in your testimony, but do you think that through the process of this, if you have somebody that's fairly severely addicted, that they're not going to avoid talking to doctors, avoid the hospital and all, so that they don't end up with that situation? And I don't know any way that you could account for how many that would represent, and I understand what your statement was previously, but don't you think it would be a natural case for those to say, I'm not going to take a chance because I don't want to be convicted?
Representative.
Thank you, Madam Chairwoman. Senator Cost. I guess, in the end, that's one of these that comes down to the policy choice. I really think that might be where the rubber meets the road on that, because at the end of the day, yes, this is the government acting like parents, that you will do what we expect of you. And I recognize that there can be relapses. I think you've got intelligent people that understand this, that would be working with the person. I don't think that the intent would just be to, try to get them. I'm surprised sometimes with this that there seems to be belief that that's what prosecutors in the system wants to do, just really get people in prison. But I guess my argument is that without this, and what I've seen in these cases, when the woman wants to basically, thumb their nose at them and walk away, there is no compliance piece. This offers the compliance piece, because it is dangerous enough that if that woman, even if severely addicted, will not do what she is told, then there are consequences. And this behavior is so dangerous that I think it's fine to have. I'm fine bringing in the criminal justice system in this instance. And again, I would also say that, having been a part of it for a very long time, we see success with having consequences, with having the criminal justice system, which offers both support. Probation agents are fantastic, right? But they are also all going to take your urine. We're going to know where you're at when you're doing this. And I think this brings it full circle, that there is a compliance piece. Because again, what I've seen before is that they walked away. The misdemeanor I just charged, I have no idea where she's at. And if I were to guess, I'd be interested to know how the baby's doing. But if I had to guess, maybe not so well.
All right, thank you, Representative Oakley. The time is 9:15. We're going to go to public comment now. We'll start with the person online. And if I could get the next speaker in the room that intends to speak to come forward in order to, I think we have another speaker here, so that makes 12 currently now. So time is limited to 3 minutes. Can I get someone with a stopwatch? All right, we are going to start online with Ms. Dole Izzo. Welcome, Ms. Dole. I hope you were able to hear me. Your time is limited to 3 minutes of comment. In order for us to hear from everybody this morning, committee members, you will have very little ability to ask questions as a result. And so I may not defer to you for questions. Ms. Dole, please proceed.
Thank you, Madam Chairwoman. My name is Elizabeth Dole-Izzo. I am the Executive Director for the National Association of Social Workers, Wyoming chapter. And I am here representing social workers who are in opposition to this bill. I will try to keep this brief. Just kind of making very clear that social workers are in line with the medical community, the counseling association, and the substance abuse treatment folks in opposing this bill because of the incarceration versus treatment. There's a couple things that are missing within this bill that make me very nervous. Is what happens to the family and the child when incarceration for a treatable mental health, physical health issue. What happens to that child? And when testimony was given on the Senate bill, the Department of Family Services representatives, had said, that when children go into foster care, there is an illusion that that is somehow a better outcome for that child. We know over time that strengthening the family is the best outcome for a child. We also know that mandating somebody to change a behavior doesn't work. Therapy and mental health treatment and substance abuse treatment is not intuitive. And it requires the healthcare provider, whether that's a physician, a therapist, a substance abuse counselor, it requires a relationship between the provider and the client that is not subject to being arrested. We know that when women are in fear of being arrested, that they would not seek out the care that they need. And ultimately, I think for many of us in this field, we want to focus on what is the issue. And the issue is having services and treatment available to women who are pregnant or parenting to improve those outcomes. And it has been shown over and over and over again that incarceration does not meet that standard. And it's logical that it doesn't. Jails and prisons are not mental health or substance abuse treatment facilities. They lack a lot of these services. And that's, I have my feelings about that, but it puts a lot of pressure on a system that is not designed to handle this issue. The other concern that I have is something that Senator Coast brought up, which was asking, why is alcohol not included in this? And the response was, well, that's illegal behavior. We are going after illegal behaviors. It is not legal in the state of Wyoming for someone under the age of 21 to consume alcohol, but that is not included in this bill. The other thing that is concerning with the language around narcotics that are legally prescribed is we all know that we have an epidemic of people being prescribed opioids. So it would miss that population altogether. I think one of the comments that was made, am I taking too long?
Yep, that's okay.
That's okay. We are strongly against this. Treatment works, punishment does not. That's my summary. Thank you.
Thank you so much. We're going to have a buzzer, hopefully ding. We do have a stopwatch here to go. There's been some more people arrive in the room. Please raise your hand if you intend to testify on this bill one more time. Time is now limited to 2 minutes, in addition to 2 more people wanting to testify on the bill. There will be a sound. Wrap up your comments at that time. It'd be very helpful for you to identify first when you speak, identify yourself, who you're with, whether you're for or against the bill, and then the remainder of your comments. Ms. King, welcome to the committee. Please introduce yourself.
Thank you, Madam Chairwoman, members of the committee. My name is Sabrina King. I represent the ACLU of Wyoming, and we are opposed to this bill. I'll try to do this in 2 minutes.
That wasn't it.
Yeah. Thank you. I'd like to push back on the idea that this is an unintentional hole in the law. Frankly, this body has been looking at this policy for over 27 years, and every single time the legislature has voted this bill down, I think because of an intuitive sense that this is the wrong policy. That intuition is now backed up by mountains of data that shows that this policy will result in worse outcomes for the baby. There's been one study that's been talked about, but in my research, I have found no less than 5. A study from 2015. It was a qualitative study of 30 women who talked about how they avoided treatment because they did not want to land themselves in jail. A study in 2015 from Cornell that looked at 15 years of data. The Faherty study, which is a study that's already been discussed, that looked at 4.6 million births across 8 states that showed that there is a 30% increase in neonatal abstinence syndrome because of this policy. And the folks who do this work are more than capable of separating the data out of just general increase in neonatal abstinence syndrome and what results from the actual policy. There was a study in 2019 from the University of Minnesota that looked at 12 years of data that showed that there's a lower number of addicted pregnant women seeking treatment because of policies like this. And in 2020, there was a study from the University of Central Florida that looked at 14 years of data that showed the same thing. Frankly, I find it a little offensive to suggest that the people who are opposed to this bill don't care about the outcome of the child, when frankly, that is the single biggest reason that we oppose this bill, is because the mountain of data and evidence that exists right now shows that you will have worse outcomes for the child if you enact policies that put the criminal justice system first. The criminal justice system is certainly part of the response to a very real issue, which is women who are addicted, who become pregnant, needing to address that. But it is not the primary way to go about doing it. This bill is the wrong policy. I will grant, and I will concede, that we do have a gap in our laws. Wyoming is one of only 8 states that has absolutely nothing on the books to address this issue. I think that we should address it, but this bill is the wrong solution. Thank you.
Ms. King, is there a good solution?
There is actually. One of the studies talks about, it's about 2/3 sort of healthcare and treatment, 1/3 criminal justice system. So there are ways to go about addressing this issue, I think, in law, but it's not this, and I think that we should take the time to get it right.
Which state has it right?
I would actually have to go back and look at the study and pull out which states have sort of the balance of carrot and stick, as it were, that actually increases the amount of women. But one of the studies that I referenced does actually, there are a couple of states where after they've implemented policies, you've actually seen an increase in the number of women seeking services. So it is possible to do.
Thank you, Ms. King. All right, next speaker. Welcome, Mr. Milia. If you could introduce yourself to the committee, who you're with, if anyone, and whether or not you're for or against the bill, and you're limited in time to 2 minutes.
Good morning, Madam Chairman. My name is Steve Milia from Cheyenne. This has been mentioned that this is a public health issue, which I agree. I have a Master's of Science in Public Health with 30 years experience, so I can say a couple of things. I support this bill, and I agree with Representative Oakley. Women need help, and the babies need protection. Using the carrot approach is best. Sometimes it works, sometimes it doesn't. So if it doesn't, the proverbial stick needs to be used. It's worked with me a few times. My parents did it, and I'm not in jail, so I guess it's okay. This doesn't necessarily restrict the availability of services, but it puts an incentive to comply. I'm not sure about the $5,000 fine, because I'm not sure where a meth addict would get $5,000, maybe $1,000, or perhaps a shorter or alternative sentence. But I do support this bill, and I support Representative Oakley, and I ask for your aye vote on this bill. Not necessarily that I disagree with the other speakers, but if the carrot works, that's great. If it doesn't, well, an alternative means it doesn't eliminate the other one, just gives an incentive to comply. Thank you.
Mr. Milia, thank you so much. Thank you for being respectful of the committee's time. Appreciate that. Next speaker, please come forward.
Good morning.
Good morning,
Madam Chairman and committee. My name is Erin Mckinney, and I cannot oppose or support this. I am here to provide education. I'm the clinical director for Women and Children's Services here at Cheyenne Regional Medical Center. I'm also the co-chair of the Perinatal Quality Collaborative here in the state of Wyoming. It's really, I know that we're all here because we want the best thing for our moms and our babies. You had a question on how long the substance stays in the mom system. In urine, it could, or excuse me, in baby system, in urine, it's could be less than a day, and in the cord blood, it could be up to 20 weeks gestation. So the most important thing of how we, in the healthcare, screen our women, it's a universal verbal screening. It is not a lab screening that we do. When our women come in, and based on that screening, the healthcare providers have an opportunity to connect the patient with the best treatment that she can have. The other thing is when all of the evidence has shown that when women are criminalized, this does not change or help them. It actually decreases their likelihood of receiving prenatal care. We know in the United States, maternal mortality is one of the highest, and it keeps going higher. Substance use and addiction is a part of that. The Plans of Safe Care is an initiative happening right now in the state of Wyoming. This was a 2016 act. It's called the Cara Act, which is a Comprehensive Addiction and Recovery Act in response to prescription drugs and opioids. This requires state to develop and implement plans of safe care. The focus of this is a public health pathway, not a criminal pathway. And in our state, there's a lot of work that's being done with multidisciplinary key stakeholders to provide moms that are substance users during their pregnancy to help support them to get the care that they have, that they need, and the likelihood of them going home with their babies rather than the babies being placed in protective custody.
You can finish your final thoughts.
My final thoughts are all the evidence shows that this is not the improvement of our women that use substances is not criminal way to help them. It is a public health way to help them. And I also want to say one more thing. In the healthcare community, we do not refer to babies as addicted. We refer to babies as exposed, going through withdrawals.
Thank you, Ms. McKinney. Appreciate your comments.
I stand for
All right.
questions.
Appreciate you so
Okay,
much.
thank
All right.
you.
Next speaker, time is 9:27. So we're going to move through a lot of you here really fast, and unfortunately, we won't be able to get very far in depth, but it's kind of how it goes. Welcome. Good morning.
Good morning, Chairwoman Nethercutt. It's really nice to see you in person. And Senators, my name's Professor Lauren Mclean. I'm at the University of Wyoming College of Law. I'm also the director of the Defender Aid Clinic, so I'm a clinical professor there. I do not appear before you in that capacity in any stretch of imagination, but in my own individual capacity as both a resident and citizen of Wyoming, as well as a criminal justice reform advocate. Thank you. I thought maybe we should talk about the fiscal concerns, given this is a budget session. This would place a substantial fiscal burden on our state and DOC and probation. Once again, we're asking DOC and probation and parole to be service providers. So this is services after prosecution. As of yesterday, I received statistics from DOC that Wyoming currently has 1,716 women on probation or parole. So think about that number for just a moment and how much it will exponentially increase if we put first-time offenders on probation. That was professed as if that was some kind of, olive branch. Well, in fact, it's not much of an olive branch to that woman, to the unborn child, or to the state, fiscally and in so many other ways. DOC also is not equipped, probation is not equipped to be the treatment providers for women who are pregnant or young children. In fact, DOC and probation are so overwhelmed, my clinic, my students help get our clients into treatment. That's how overwhelmed they are. Also, once the woman does fail on probation because we're not adequately equipped to support her, a local county jail stay per night, let's just start with Fremont County, $75 a night, $65 a night in Johnson County, $107 a night in Laramie County. In Lusk, once they go to prison, $101 a day. And this is statistics from DOC as of this morning, actually. In addition to the fiscal concerns, I also worry about the stigmatization and the fiscal concerns that might follow that. If I may, just very briefly, what we're going to do here is we're still going to give the woman of the and the mother of the unborn child a felony conviction, and that felony conviction will cause not just great, she gets to go on probation and get treatment, but in fact will result in cyclical travesty. She will have to struggle with getting employment. She will have to struggle with earning a living wage to support her child, her family, and ultimately DFS will get involved. And when DFS gets involved, we're going to litigate that for 6, 18, 24, 36 months? It costs more and more money, a floodgate of litigation. So please understand that this bill is not fiscally wise. Thank you.
Appreciate you being here. All right. Welcome, Ms. Somerville.
Madam Chairman, thank you. Andy Somerville, Executive Director for Whamsack, Wyoming Association of Mental Health and Substance Abuse Providers. I want to start briefly by just letting you know that our colleague Cheryl Folan from the Wyoming Association of Addiction Providers is not able to be here today, but they do oppose the bill, and I believe they've sent you a statement. On behalf of Whamsack, we do oppose the bill. I'm not going to repeat a lot of the stuff that was already said, but I want to talk to you as the provider for parenting women residential substance use beds in Wyoming. We're it. There are 3 locations in Wyoming where we have these beds. They are in Casper, Rock Springs, and Sheridan, a total of 21 beds for the entire state. Just one of my facilities right now has 16 women on the waiting list and an average of 6 months to get into residential treatment. So as we talk about this policy, and as the speaker before me talked about fiscal concerns, we certainly have that concern. Under behavioral health reform, which is moving through, we are, as required to serve a priority population under DOC. This would include these probationers, and we do not have the facilities or the resources to handle a massive increase. Now, I don't want to say that negatively because we want to treat these women. We want to provide these services. But as many of you who have been around community mental health know, the system is underfunded and always under strain, and we're always looking to improve that. We are participating with the Maternal Child's Project and Safe to Care planning to try to increase that. We work routinely with DOC. As you recently saw, we've asked for money in the ARPA bill that was approved yesterday for crisis and women's services because we are already lacking in this area. We do not want to drive women away from care. We want them to come to treatment, and we want to work collaboratively with everyone to make sure we have those resources on the ground. And I just want to say residential treatment, it's just not, parenting women are either pregnant or they have young children they bring with them. These programs are all encompassing. It's not just about the mother, it's about the family unit. They don't leave us without having a job lined up, housing, all the services wrapped around because we want them to be successful. Madam Chairman, I would stand for any questions.
Thank you, Ms. Somerville. I appreciate you being here. Next speaker. Time is 9:33.
Thank you, Chairwoman Nethercott and Senators. My name is Dakota Duran. I'm currently in my 3rd and final year of law school at the University of Wyoming College of Law. And I have also have experience in public defenses at the trial, post-conviction, and innocence stages. But I come to you today in my own individual capacity as well. I'd like to be clear that in this argument, I'm not speaking for any particular community or anyone else other than myself. The only experience I'm here to share with you is my experience within the criminal justice system and how marginalized communities will be harmed by the passage of this bill. There are some statistics from Wyoming that you may not be aware of yet. First, the latest census tracking came out last year, and as a state, Wyoming's racial makeup is one of the least diverse in the nation, with 92.5% of the population being white, leaving 7.5% of the state population being one or more various different minority communities. The troubling numbers actually come out of DOC statistics. Currently in the Lusk Women's Prison, 19.5% of the total population is minority makeup, with a heavy number of those being Native American women. That's over 2.5 times the statewide population makeup. This statistic is even worse when it's juxtaposed against the fact that Wyoming has the 5th highest rate of incarcerating women across the nation. Supporters of this bill will counter by saying that first-time offenders will only face probation. But if you look at those numbers, it's 11.94% minority makeup of women on probation and parole here in the state of Wyoming. Additionally, as this committee noted earlier, consumption of these substances is already illegal, and this does nothing for the women on probation or parole that Representative Oakley has referred to as a problem. Representative Oakley also stated earlier that mandatory reporting does not apply here, and yet I see no exception carved out in House Bill 85, nor an exception in the mandatory reporting statute that would prevent this from happening. Thank you for your time.
Mr. Rand, thank you for being here. Good luck at school. All right. Welcome.
Madam Chairman, members of the committee, my name is Lindsay Simino, and I represent the Wyoming Counseling Association. The Wyoming Counseling Association and its providers oppose this bill. When asked what is the right solution, we do believe that the Comprehensive Addiction and Recovery Act that mandatory or that offers a plan of safe care, we do believe that that is the right solution because it is prioritizing that public health piece, which is what we are wanting for our pregnant mothers, which is what we are wanting for our children, for those children to have better outcomes. There was a point made that there is a case in Kentucky where the numbers went down of children who were born experiencing withdrawal. It's easy to argue that that is because of that law. We would also counter argue that we do not know why that happened, that it could also be that women are not going into those hospitals, so those cases are not being reported. And so I would say that because of situational and environmental factors, we do not know why that went down in Kentucky. Also, we would agree that even though this could give prosecutors a chance to have extra leverage within the court, that the unintended consequences are going to be far more greater when these pregnant mothers are not able or feel as though they are not able to receive that prenatal care and also receive that substance abuse treatment. I stand with what my colleagues have already said, and I also stand for questions.
Thank you, Ms. Semino. Appreciate hearing from you. Those who are still interested in testifying that are in the front of the room, if you could start moving yourselves to the front of the room so you're on deck, ready to go. Good morning.
Good morning, Chairwoman Nethercutt, members of the committee. My name is Travis McNevin here on behalf of the Northern Arapahoe Business Council. The council stands in opposition to this bill. Much like many other speakers here today, they believe and feel that this bill will lead to a number of unintended consequences. Native women on the reservation, there is a struggle to get the prenatal, postnatal care checkups, going into the hospital, those sorts of things, as is. This is just a challenge. Unfortunately, addictions are also very much a challenge. The concern, obviously, with the unintended consequences would be that this bill would further restrain the decision-making of going in and getting the health pre and postnatal care. Additionally, with the potential felony nature of the bill, that should women and treatment begin to get life going in a positive direction, that things like housing, education, employment, Pell Grants, all of these sorts of things down the road become that much more complicated with a felony on the record as it relates to SNAP, Pell Grants, et cetera. And so both before and after, certainly a great deal of concern with the unintended consequences. And to Senator French's very insightful comment earlier of where these births would take place, certainly feel like this would lead to more at-home births instead of going into the hospital. And again, where proper care and treatment options are probably less likely to take place. And so for all of those reasons, stand in opposition to the bill.
Mr. McNevin, thank you for being here. All right, perfect timing. Welcome, Director Schmidt. Good to see you this morning.
Thank you, Madam Chairwoman, members of the committee. My name is Corin Schmidt. I'm the Director of the Department of Family Services. I'm just here there's sometimes an intersection between the criminal justice system and Title 14, the juvenile court system, which is where we do most of our work. And so I'm here for if there's any questions about that intersection. And then also we just have a small amount of data on substance-exposed infants that come into our care or to our attention.
Director Schmidt, briefly, when a baby is born and tests positive for illegal substances, what happens?
Madam Chairwoman, one, that's going to depend on the hospital. That's where it's first recognized. And if there's indications or whatever the policy is at that hospital, they may test the baby. If they test the baby, medical personnel and law enforcement are the only two authorities that can remove children from their mother's custody. Oftentimes we'll get a call prior to that custody being, that child taken into protective custody. Sometimes we won't. If the child's taken into protective custody, then we get physical custody and then the Title 14 proceedings start. Out of 115 infants last year that we know of, and this is again a very small data set because we do not have statewide data and we do not have data on every child born. However, out of 115 infants that came to our attention, 37 last year were taken into protective custody.
Thank you, Director. Appreciate your time here. Wish we could ask you more questions, but we will hear from everyone. Ms. Muir.
Good morning, Chairman Nethercott, committee members. My name is Tara Muir. I'm the Public Policy Director with the Wyoming Coalition Against Domestic Violence and Sexual Assault. We rise to stand opposed to this bill. Too often, victims of rape in particular are not receiving the good crisis intervention they need. Rape is very traumatic. So survivors often are much more vulnerable to substance use disorders. When we talk about domestic violence, too often abusive partners use alcohol and drugs to maintain control over their intimate partners, even barring access to care, whether that's prenatal care, health care. They often are the ones who get victims addicted as well and use that addiction against them, whether it's custody proceedings or when she does finally want to call law enforcement. She's the addicted one. She's the one out of control. I'm not. I'm happy to take any questions. I want to be short.
Ms. Muir, thank you. Appreciate hearing from you. All right, next speaker. Time is 9:42. Looks like we had some people drop. All right. Representative Oakley. Good luck.
Thank you, Madam Chairwoman. Okay, I'll start.
And you have 3 minutes.
Okay, starting from going down the speaker. So the first speaker said treatment works. I agree. Let's make sure that they complete their treatment. A lot of discussion about studies saying that they avoid treatment because of incarceration and their knowledge of the laws that are in place. If we're assuming that they're making sophisticated assessment of consequences, then they will know that we started this bill with treatment and probation and help. So there was a discussion about at hospitals, they do verbal screening and then they get the appropriate care and referral. All of that is still in place. Most everybody you heard from, all of these government-funded directors of programs, that's great. All of those are still in place. Like, this doesn't create a fundamental shift that we are going to do, that as a state, we focus on treatment and care. It's included in this bill that that's what we will continue to do. I will say, I forgot to mention this before in discussion with the felony conviction. I included something also new in this, and I put it in as an amendment. This would be allowable for a deferral, both under 713-301 and 35-7, 1037. There's also no other statute where there's 2 different options for a deferral under this. So we could look at deferral so the felony conviction wouldn't actually go into place. Again, just so we could have that compliance piece. Discussion about the DOC and what a substantial increase it would be. DOC testified they do not expect that this would be an increase in any way. All of these systems are already in place, again, from all the people we've heard from, as well as probation agents. There is no expectation that would increase as far as like taking a fixed cost and then saying each one would add. That's just not how it works. Discussing like Whamsack and then the priorities. Again, with this talk about it would be a substantial increase. There is no thought or evidence that this would be some substantial increase of anything. But I would argue to you that, interestingly, if that were the case, if all of a sudden this was a deluge and it identified a problem, then we need to prioritize this. In probation and parole in Fremont, about half, 180 are on probation for felonies and 140 for misdemeanors. If this somehow pointed out a deluge that was a substantial increase, then we need to prioritize this. And they can still, as I said, get all the care, all the help from the counselors, the treatment. We heard from, again, Whamsack that this place that has parenting women is already, we need more beds. Then let's do that. I'm all for that. But if we identify more of this dangerous, tragic consequence behavior via this, then that would, to me, would be a proponent of the bill. So with that, I think that this is something in our law that that we should consider prohibited illegal conduct. And all of these good people in the room will still be there helping people if this helps identify and holds a woman accountable so that that child can get the best care and can be taken care of. And I think that's something we should do as a state. Thank you.
Representative Oakley, your thoughts about bringing this up as an interim topic? Today is the deadline for the Joint Judiciary Committee, of which you're a member of.
Thank you, Madam Chairman. I think that this bill is ready to go forward. I don't think that, I personally think it's a policy choice. I think this is very straightforward. This makes it a prohibited conduct. It's very short. It adds a criminal statute, as we've heard, so we can get more testimony that it increases, cost to the DOC, and I don't think that's true. We've already heard that. I think it's a policy choice, so I don't think that it is something that further discussion is going to change anybody's mind. I think we have discussed it. I stand behind where it currently is, and I'd ask that you vote aye.
All right, thank you, Representative Oakley. Senator French. Stig?
Thank you, Madam Chair. Representative, so they get caught, and the first one's probation, the first time around, right? Well, the second time around, up to 5 years in jail or in $5,000. But it's not necessarily that, is it? Because in the court system, the county attorney may bargain for a lesser charge, or the judge may do something. Doesn't automatically mean that second time around it's 5 years in prison and $5,000. Not being in that system, I'm not sure, but where I believe you are, maybe you can comment further. Thank you.
Representative, judicial discretion.
Thank you, Madam Chairwoman. That's a great question, and what I would say is I absolutely agree. Even so, your scenario, it would be the second time they were found using methamphetamine when pregnant, and even then, I can almost guarantee you that it's going to be probation, and it's going to be do a urinalysis, have a probation agent, get it right, get it right, get it right. In the criminal justice system on these cases, over and over and over, we do, whether it's revocations or working with, it just adds a more robust system around the woman to make sure that she gets it right. Very, very infrequently is somebody going to go to prison for this. It would have to be such willful non-compliance. But it does have a compliance piece because of having the criminal justice system that they tend to get it right more often. And I think that it's important enough to protect children to have that in place.
All right, thank you. Public comment is closed. Time is 9:48. For purposes of posterity for this video, and a number of speakers in the room that raised their hands chose not to testify. I think there was about 3 or 4 of you that did that. You're certainly free to do that, but just to explain why the committee has more time than what was anticipated, and a little bit of understanding from a chairman's role in navigating time restraints associated with public meetings and the desire of the public to comment. So with that, committee, back to you. Moved by Kolb, seconded by French. Further discussion on the bill? Senator Cooper?
We heard a lot of really great testimony here today. Some of it relevant, some of it not so. But when you go back and read the bill, it's pretty clear. First offense is treatment and probation. I think that's really important. And the harsher penalties kick in for subsequent offenses, as they should. The thought of a felony following that person through life, yeah, that's the consequences of committing a felony. So, yeah, I think when you read the bill, it does what we need to do.
Further comments? I do have concerns about the bill. I would like to see it more as an interim topic. I think the inability in a budget session to have robust conversation associated with best practices with this very important type of legislation. This law is not on the books, and I think that that's a telling piece that for Wyoming's history, which is certainly in favor of protecting children and tough on crime, that the policy and wisdom of the legislature is not to have this be a crime. That's important. But what we've also heard is that there's a gap. And we've also heard testimony that there might be some smarter solutions to addressing that gap. And I don't think we've heard all of those options here today in the 40 minutes of testimony we've been able to receive. I was also troubled, and I'm troubled that the committee and other committee members didn't identify a comment from our Director of Family Services, which indicated that there's no statewide data, which I find completely unacceptable, that there's no statewide data associated with the amount of babies born in our state that are exposed to these types of narcotics. And so if we really want to understand how to address this issue, I think that is a fundamental place to start. And a further understanding of as to what that process looks like for families that are facing this circumstance and mothers who have chosen to expose their children and babies to this environment. And I just think we can maybe do more thoughtful work. So with that, I'm a no vote, but that's why. And I actually look forward to learning more about this issue. Senator Cole.
Thank you, Madam Chairwoman. I'm a yes vote on this, and I'd like to explain why. First, few questions. What's a child's life worth? You know, we have an issue here with treatment programs that obviously there's a gap, and it's led into court situations where people are trying to deal with the child and to protect the unborn. And I think currently it seems reasonable to me that we try another avenue and we go this route, because what we currently have is not working well. It's clear we have problems. And I think this may be an avenue. I think it is worth certainly going down this road. That's why I'm going to vote aye. Thank you, Madam Chairwoman.
Roll call.
Senator Cooper.
Aye.
Senator French.
Aye.
Senator Cole.
Aye.
Senator Koss.
No.
Chairwoman Nethercott.
No.
Madam Chair, House Bill 85 engrossed passes with 3 ayes and 2 noes.
With that, meeting is adjourned. Thank you.